I move the question be now put.
I'm going to call the Honourable Mary Ann Street.
Thank you very much, Mr. Chairman. I rise to speak to Part 2 as well of this legislation. Mr. Chairman, in the explanatory note at the front of this bill, there are some bullet points that relate to matters in the bill to which errors or omissions will be corrected. In other words, this is why we have an amendment bill to the Amendment Act, because there are errors or omissions that need to be corrected. As it happens, Mr. Chair, they all fall in within Part 2. They start with the definition of underground gas storage facility, the definition of offshore area, which is Section 14, Clause 14, which members have been discussing recently. In references to reserves being changed to resources, which was a matter that the Minister referred to in his introductory speech, extensions to existing petroleum permits, addition of platinum group metals to the list of mineral types with the same Tier 1 thresholds as for gold and silver, clarification of the application of the Crown Minerals Act 1991 to existing privileges granted after that Act came into effect, clarification of the proprietary status of permits acquired by the Crown, and references to a dwelling house. Mr. Chairman, that is 8 items that were errors or omissions in the bill that was passed just a matter of weeks ago. 8 errors and omissions. Mr. Chairman, I'm beginning to wonder whether the Minister has just about begun to understand the importance of the Select Committee process. With 8 errors or omissions being corrected in this amendment bill, perhaps now, after hours and hours in the House under urgency on this, the Minister might be beginning to understand the importance of going to Select Committee. Going to a Select Committee where people with expertise can help MPs get the law right. The policy position we can argue about, and we are arguing about, particularly with reference to Clause 14, Mr. Chair, but the policy position at least ought to be expressed accurately in the law. But for these 8 points that are missing or are incorrect, all of which fall within Part 2, we are here under urgency instead of observing the proper process which might have rescued this Minister from these hours of purgatory as he's had to listen to one speech after another berating him for his incompetence and his inadequate approach to the legislation. So I would like to ask the Minister if he prefers this kind of repeated drubbing in urgency, or would he rather it went to a Select Committee where people can have some say and where, in fact, improved legislation may be the result. Mr. Chairman, I'd like to focus a little bit on Clause 13, which is unusual because Clause 14 is the lightning rod in this part. But Clause 13, Part 1, says that in Section 52, new Section 99B1, replace dwelling house, spelled as 2 words, with dwelling house, spelled as 1 word. Dwelling house, spelled as 2 words, dwelling and house, to be replaced with 1 word, dwelling house. We are here at 11:30 on a Friday night to turn dwelling house into dwelling house.
It all makes sense now. It all makes perfect sense.
I wonder if the Minister could clarify why that should be the case. Why are we here taking a space out between 2 perfectly legible and understandable words and putting them into one? I presume there is some significance in that. and it has a particular meaning. And had I been able to ask at a select committee, I might have been able to find out. If this is bringing dwelling house into the same... Mr Chair, I haven't finished. Mr Chair, Mr Chairman, I haven't finished my points.
I'm going to call the Honourable Phil Goff.
Mr. Chairman, I wasn't going to take a call on